the last unit of our syllabus, that is relating to the elections, syllabus relating to the constitution and the elections and the amendment of the constitution. These are the two topics which we will be discussing. First of all, what are the provisions relating to elections in our constitution? Article 324 to Article 329 speak about the electoral process of our constitution and the powers and functions of the Election Commission of India. First of all, we know that ours is a democracy, and democracy is always kept alive by conducting free and fair elections. It is also the privilege of a citizen to participate in the electoral process. Here, as we say, we the people of India. So we the people of India are the source of power from which our constitution derives its authority. Therefore, in India, we have universal adult franchise. We have already seen that. And all persons above 18 years of age are allowed to participate in the elections. So, in the electoral process, how the things take place and what are the different processes which are taken, we will go to these provisions. First of all, Article 324. 324 says that there shall be a Election Commission of India, which is consisting of the Chief Election Commissioner and such number of election commissioners as the President may fix from time to time. That means the Election Commission is appointed by the President. And the appointment of the Chief Election Commissioner is made subject to the provisions of any law made in that behalf by the President. So if a law is made by the Parliament and there is any conditions relating to that, subject to that law, the appointment takes place. One condition is given or one provision is there wherein it says that, see, the Chief Election Commissioner being the main constitutional authority to conduct elections, and in order to conduct fair and impartial elections, it is required that the Election Commissioner is given powers which are independent from control of any other authority. It is required that it is necessary that he should be independent, and therefore Article 324 subclause 5 324 subclause 5 says that Election Commissioner cannot be removed from his office except in the like manner as a judge of the Supreme Court. So we have seen how the judges of Supreme Court can be removed. So in the same manner, there is a provision that if at all the Election Commissioner has to be removed, he can be removed according to the manner in which the Supreme Court judges can be removed. So the impeachment of judges, that provision applies. Now, further it says that 324 subclause 5 says that the services of Chief Election Commissioner cannot be varied to his disadvantage after his appointment. That means after the Election Commissioner is appointed, his conditions cannot be changed, nor his salary can be reduced, nor whatever the conditions of service are stated in his appointment can be altered. It cannot be, any changes cannot be done in the different, what you call as service conditions of the Election Commissioner. So this is Article 324. It says that the superintendent's direction and control of the elections. That is the function of the Election Commissioner. The superintendence, the direction, and the control of the electoral process of the elections is in the hands of the Election Commissioner. So this is how the Election Commissioner has been given an independent post. Now, uh, there is one Article 326 which provides that in India the election is based on adult suffrage. So adult suffrage means every citizen of India who is an adult, and that adult is 18 years of age, he is entitled to vote at the election, provided that he is not disqualified under any provisions of the Constitution. If a person is he or she reaches 18 years of age, he is entitled to vote. That is provided in 326. Then, what are the powers and functions of the Election Commissioner? First of all, Article 324, as I said, it says superintendence, direction, and control of elections. That means whatever is required, all the powers necessary for a smooth and effective control of elections. Smooth and effective conduct of elections shall be governed, shall be given to the functions of this election commissioner to exercise. So, wherever the people have to vote, or wherever the elections have to be announced, or wherever the procedures relating to the election has to be announced, everywhere all these powers are controlled by and regulated by the election commissioner. Now, the election commissioner, as we said, superintendence, direction, and control. This is the first. It covers everything. But again, in detail, what are his functions? For second function is he prepares. Second, in the sense, it is part of that. He prepares electoral rolls. He means the election commission, which is a joint. It is a commission which may consist of one chief commissioner and more than one other commissioners. They don't say assistant, they say other commissioners. So all work together. So the election commission prepares electoral rolls for the elections to parliament, state legislatures, local bodies, and also it ensures the security of the nomination papers. It ensures that they are kept secure. This is the second point. Then the election commission lays down general rules for the conduct of elections. All the rules for elections are laid down or notified by the election commission. They issue notification of dates and schedules of the election. Whenever the election is to be conducted, the whole notification is issued by the election commission. Of course, the declaration for the elections is made by the President of India. The declaration for elections, that is, the elections are declared through the President, and the notification is issued by the election commission. Then, next, the election commission determines the code of conduct in the elections, and it is to be observed by the parties and the candidates. Whatever rules are there to be observed, that is, what is the manner in which they are going to conduct themselves during the elections, this is prescribed by the election commissioner. Then the election commission allots symbols to parties. Whenever a new party is formed, they apply to the election commission to approve their symbol, and that symbol, if is according to the rules, the election commission allots the symbol to the parties, and it also, the election commission recognizes the parties. It accords recognition to the parties. Then the election commission also renders advice to the president, wherein any question relating to disqualification of members of parliament is in question, then, or in the state legislature where there is a question of disqualification of members of parliament, then the election commission renders advice to the state legislatures, or to the governors and to the president, governors in the state and president at the center. Then the election commission has also the power to postpone the elections on specific mandates. Suppose the election commission is satisfied that elections cannot be conducted at a particular time, then they have the power to even postpone the elections. Then the election commission also appoints different election officers for inquiring into the disputes which arise during the elections. Any disputes relating to the arrangements of elections, any disputes which arise. To decide about that, the Election Commission appoints members or election officers. These are all the functions of the Election Commission. So if there is a question, what are the functions of the Election Commission? All these points have to be remembered. Then, what is the electoral procedure under the Constitution? What is the electoral procedure? See, here, as I said, the Election Commission has the power to decide the conduct of the elections. Therefore, the whole procedure is supervised and whole procedure is notified and taken care of by the Election Commission in details by appointing several officers to the particular tasks. The Election Commission has to decide, first of all, the schedule of the election. Then either he has to according to the, suppose the election is to the parliament or the election is to the state legislature. We know that the parliament members, the members of parliament are elected by the people. So whenever it is to be scheduled, the election commission has to decide. Whenever the state legislature election has to schedule, the election commission has to decide on that. But for that, he also receives the recommendation of the government. The government recommends to the election commissioner, and the election commission decides about the schedule. This is the first starting of the electoral procedure. Then next, he starts the process once the president or the governor notifies the elections. So the president notifies the elections at the central level, at the union level, and the governor notifies the elections at the state level. Then the election process starts. Then the voters are called upon to elect their representatives, and the election process starts in the country. Normally, how many days are allowed for filing nomination papers? Now, this is the process. See, for once the election is scheduled and it is notified, the people started, the candidates start to file their nomination papers for their candidature. For this, there are 8 days time is allotted to file the nomination papers. Then, what are the conditions or qualifications of the candidates? We know that we have a political justice in our preamble. Everyone is given a opportunity. Everyone has a opportunity or a right to stand as a candidate in elections, provided that person is not uh, is not is not disqualified under any law. So the election process, once it is started, they look into the filing of the nomination papers in beginning, and only condition is the candidate must be a voter in the country, and then he is qualified to be a candidate. Secondly, that candidate who proposes his candidature must be from the concerned constituency where the candidate is contesting. Suppose a candidate wants to contest from a particular constituency, he should be a member of that constituency. That is the only required rule, that is a required condition for him to stand as a candidate in that constituency. So a individual may even contest from any number of constituencies. As you know, there are several instances where a person has contested from 2 or 3 constituencies also. So this is the third point. Next, once days time is given to withdraw, then afterwards, when this time lapses, it is over, then the returning officer, there are details about what are, and according to section 123 of the Representation Act, it is mandatory to disclose the who is standing for election has been convicted in is a candidate in the election. And according to the Supreme Court information, so after that in 2003, there was a what is the function and powers of any doubt? Please, you can. Okay, so I will go to the next of the Constitution. Now, it is a moving, what you call as it is being enacted, Constituent Assembly, which is solid and permanent. the constitution rich in the amendment of the constitution is. So the constitution, it is called as a living document. Why? Because a living grows. In India, as we said when we were discussing constitution, is you can say it is combined both the features. The constitution itself, we have Article 368 in the constitution. Article 306 the constitution. The procedure and the power to amend the constitution. First is by special majority and 3 ways of amending the constitution under Article 368. Simple majority, 1% if you for any resolution, for the thirds of the people have to amend. Just the parliament by majority, if it passes by simple majority and amends the constitution, then if there is a complete majority of by some, therefore for some important provisions there is a provision that and into a act parliament, it is sent to all the state legislatures, and out of agree, that is have to consent and approve that amendment draft of the constitution, then only it will be held to be completely approved by the country. So and then the amendment will take effect. So the first one, simple majority. See, simple majority means parliament by simple majority can amend and pass the legislation, that is the bill for amendment, and it is not subject to special procedure. See, for example, Article 2, the power of Parliament to admit a new state in the Union of India. Just by simple majority, the Parliament can pass a bill in the Parliament. The bill can be passed by majority, and it can be new state can be admitted in the Union of India. Under Article 11, the acquisition of citizenship and termination of citizenship. For that also, easily the parliament can be amended by simple majority. Again, the salaries and allowances of certain officers are stated in the second schedule of the constitution. If the parliament wants to amend that, see, the parliament only has the power to determine the salaries and remuneration of the governor, president, prime minister, council of ministers, judges, etc. So if that provision has to be amended, that is the schedule has to be amended, it can be done by simple majority. Fourth, the members of parliament have their own privileges. The privileges of the members of the parliament also can be amended by the parliament by simple majority. Then that is specified in Article 105. Then Schedule 5 and 6 dealing with the scheduled areas and the scheduled tribes. We spoke about the SCs and the STs. So whatever there are two schedules for this, Schedule 5 and Schedule 6. If that has to be amended, the Parliament can amend it by itself by simple majority. Then under Article 169, special legislative councils, if they have to be created. I told you that only 5 states have legislative councils. All other states have only legislative assemblies. Suppose some state wants another house, or the second house, or the upper house is to be constituted, that also can be done by the parliament by simple majority. So these are the provisions which can be amended by simple majority. Second, special majority. Now, which are the provisions which can be amended by special majority? See, here the provisions are amended by introducing an amendment bill in the House of the Parliament. Then first one house has to pass it by total majority of not less than 2/3 of the membership of the persons voting, present and voting. Number one. Second, that bill is presented to the president. Both the houses have to pass the bill, and it goes to the president for his assent. And on the date on which he assents, the amendment comes into effect. So there are certain constitutional provisions which can be amended by this process. So after this happens, then such provisions can be amended by special majority, which are being stated. Next, very important provisions which even may be concerning the state legislatures. For example, election of the president under Article 57, amendment to Schedule 7. Schedule 7 deals with the lists union list, state list, and the concurrent list. Suppose any amendment has to be done to that. Then amendment to Article 368 itself, if it has to be done. Or the union and state judiciary, which is independent. Suppose there are any provisions which have to be amended. Then there is a special procedure, that is, the bill has to be passed by both the houses of parliament. The bill then will be sent to all the states and the state legislatures. All the state legislatures, if they are having two houses, both the houses, if they are having one house, the state legislative assembly will pass that bill by majority, and one half of the state legislatures have to agree to it. That is the ratification to that bill. Again, it comes back, and then the president gives his assent to that bill, and the amendment takes place. Now, see, here we discussed about the amendments can be done, but there are certain things which cannot be amended. There are certain basic features of the Constitution which cannot be amended under Article 368. See, for example, when we speak about the fundamental rights, there was a question whether the fundamental rights can be amended or not. There were several amendments done. See, for example, there was an amendment in 1964, the 17th Constitutional Amendment, where a ninth schedule was inserted. Okay, and it was questioned. It was questioned. Then in 1967, certain things were amended. Then again, coming to the 24th Amendment. In the 24th Amendment also, several things were changed. Now, there came up 24th, 25th, and 29th. Three amendments had taken place, wherein some provisions relating to the ninth schedule, some provisions relating to the right to property. Right to property, the repeal of the right to property was done later on. But before that, when there were certain laws introduced, and there were the ninth schedule was introduced, saying that court shall have no say in the matter when any law is put in the ninth schedule of the Constitution. So one new schedule was created in the Constitution, and the Parliament put in the provision there by amendment that if any law is put in the ninth schedule, then nobody can question that law, and it cannot come before the any court of law. No court can decide whether that law is void or what. See, what we said is fundamental rights, if any law is made against the fundamental right, it will become void. But then when you say that a law is made and it is put in the ninth schedule, you cannot go before the courts. That means your right is curtailed. So this was challenged before the courts in several cases. The most important case which deals with this is Keshwananda Bharti versus State of Kerala. In this case, a writ petition was filed to challenge the Kerala Land Reforms Act of 1963. That was placed in the ninth schedule. Land Reforms Act, wherein in this case there were 13 judges, and 13 judges delivered a landmark judgment in 1973. That was on 24th of April 1973, wherein it laid down an important provision. That is, it said that according to Article 368, whether there is a power to amend the Constitution, yes, there is a power to amend the Constitution. Secondly, according to Article 368, whether fundamental rights can be amended, yes, they can be amended, provided that any amendment which is done cannot take away the basic structure of the Constitution. Just remember this. This case is a very landmark case because it brought in the concept of basic structure. What is a basic structure? See, when any building is constructed, first of all, you form the foundation. You form the basic structure after that. That is, the structure of that building is planned according to that basic structure only. Suppose you have to modify, later on you want to modify that building, you want to modify that structure. What happens? You modify the building, you can change your structure in some manner, but you cannot change the basic structure which forms the foundation of that building, because once you try to interfere or make any changes in the basic structure, the whole building will collapse. So that is the theory which was used by these 13 judges in this case. They said that whatever you can amend in the constitution is like a foundation or a basic law of a land. Therefore, there are certain things in our constitution, certain provisions in the constitution, which, if they are tampered with, then the whole system, which is our constitution, that is our democracy, which is part of our constitution, or the constitution which has created our democracy, the whole structure, whole system will collapse. Therefore, you can amend the constitution, but you cannot amend those things which form the basic structure. Now, what are the things which form the basic structure? The judges listed several things. They said democracy, then secularism, fraternity, justice, equality. See, there are so many things which are the foundation stones of our democracy. There are then our elections, our election procedures, or our election process, or our independence of the judiciary, or our independence of our parliament. These are the things which form the basic structure. You can't change it. You can't overnight change it. You can't, even by any special procedure also, you cannot amend the provision. So here, this basic structure theory was set up in the case Keshwananda Bharati versus State of Kerala. Please remember the case Keshwananda Bharati versus State of Kerala in 1973, which stands till today as a landmark judgment. Okay, now coming to this, after we have seen all this, we can now see which were the important amendments which have taken place from the beginning. We are not going to go to all the amendments. There are several amendments, that is up to 100 amendments and more have been taken place, but we will go to the important amendments which have been done. Okay, the first, any doubt till now relating to this amendment procedure? See, there are the three ways or three modes of amendment we have discussed. Then we have discussed whether the rights can be amended. We have discussed what is the procedure of amendment, and we have discussed the case Keshwananda Bharti versus State of Kerala, where the basic structure concept was laid down by our Indian judiciary. Okay, then coming to the First Amendment Act of 1951. This was made within 1 year of the commencement of the Constitution. The First Amendment Act in 1951. Under this, certain restrictions were added to the freedom of speech and expression under Article 19, Subclass 1. That is public order, friendly relations with foreign states, and incitement to an offense. These three grounds were added as restrictions to the right to freedom of speech and expression. Then Article 31, that was dealing with right to property, fundamental right to property. There were certain things, amendments were made by adding Article 31, 31A, 31B, and 31C. 31A and 31B to the ninth schedule, and the zamindari system was abolished by law reforms. So for that, with regard to that, certain law reforms act were placed in the ninth schedule. So ninth schedule and the 31A and 31B was added by the first constitutional amendment. This was challenged in the Supreme Court, but the court upheld the amendment, so it stands. Then after that, the important amendment is of 1971, 24th Amendment, wherein Article 13 and Article 368 were amended. In Article 13, that is the power of Parliament to amend the Constitution. What was the question was, earlier in the heading or the marginal note to Article 368, it was given procedure to amend the Constitution. So they changed that to power and procedure to amend the constitution. So we have to show that power, the parliament has power to amend the constitution. This was made by the 24th Amendment, 1971. 1972, Article 31 was amended. 25th Amendment. 25th Amendment, Article 31 was amended, where under Article 31, whenever the property was taken for a public purpose according to the procedure of law, there was an amount to be given to the person who was the owner of the property. That word amount was removed and compensation was put. So compensation means you have to give a proper amount, which is compensating him for the property. That was added. Then 31st Amendment in 1973, wherein the upper limit for representation of states in the Lok Sabha was increased. So for the states, it was from 525 members in the Lok Sabha, it was increased to 545 members. And for union territories, it was 25 members. It came down to 20 members in the union territories. That was added in 1973. Then the next very important amendment is 42nd Amendment of 1976. We have discussed this amendment several times in our discussions relating to fundamental rights and fundamental duties. What were the things which were amended in this? Please remember these things. These are very important. 42nd Amendment of 1976. It has important amendments. First one, they amended the preamble. In this 42nd Amendment, the preamble was amended. Two words were inserted. Where we had in the beginning, constituting India into a sovereign democratic republic. Then they added two words, socialist and secular. So now we have India is constituted into sovereign, socialist, secular, democratic republic. This was these two words, socialist and secular, were added in 1976. Then one more word was added. That is, at the last, it was said that the unity of the nation, assuring the dignity of the individual and unity of the nation. There, and integrity was added. So, assuring the dignity of the individual and unity and integrity of the nation. That and integrity word also was added in the preamble. So, preamble was amended. Secondly, so before this amendment, the question whether the member of parliament is disqualified or not was to be decided by the president with the opinion of the election commission. This procedure was amended in Article 103 under in this particular 1976 amendment, saying that the president should obtain the opinion of the council of ministers before he decides about the disqualification of ministers. So the president's powers were again limited by saying that he should consult the council of ministers before he decides the disqualification of ministers. Thirdly, thirdly, Article 74 was amended, and there it added that the president should act according to the aid and advice of the council of ministers. That provision was added. So now, whenever the president takes any decision, he is to act according to the aid and advice of the council of ministers. Then after that, these were the important amendments. Secondly, under the 42nd Amendment, there was an amendment by adding 51A to the Constitution, which consists of our fundamental duties. Fundamental duties were not there in the Constitution. There 10 fundamental duties were added by the 42nd Amendment in 1976. Okay, then after that, the 74, 97, the power of the judiciary also was curtailed. Then center and state relations like education, forest, protection of wild animals, all these were taken out from the state list and placed in the concurrent list by this amendment, 1976 amendment. One more thing was amended, that is under Article 352. under Article 352, there was a provision that a president can declare emergency throughout the country, or only in a part of a country. But here, the president can declare the emergency throughout the country or any part. There it was only not only in one part, but throughout he has to declare emergency. That was changed, and now he can declare either in part of a country or throughout the country. Then the effects on fundamental rights. Article 31C was inserted. Article 31C was inserted, where there was the principles of state policy will be given importance over the fundamental rights. Then there was a new article in the Directive Principles introduced, that is Article 39A, 43A, 48A, were introduced in a part 4 of the Constitution, that is the Directive Principles. We have discussed the Directive Principles in details, that is relating to the environment, relating to the social, the different social measures to be taken, and these provisions were introduced in 1976. Then, fundamental duties, new chapter, as I told you, was added. These are all the different amendments in the 42nd Amendment. Coming to the next important amendment, that is the 44th Amendment to the Constitution of 1978. 44th, of course, 42nd Amendment was very important, but it was very controversial. Several things were amended by the 42nd Amendment, and people did not like several amendments, and therefore there was a demand for removing some of those provisions, and removing some of the amendments which were done in the 42nd Amendment of 1976. Now, 44th Amendment in 1978 made certain amendments. It restored certain provisions and changed certain provisions. What were the things done? By the 44th Amendment, they have amended by removing the right to property from the fundamental rights totally, repealing the right to property from the fundamental rights, Article 31, and also Article 19(1)(f), the power to the right of a citizen to hold property, to dispose of property, and to acquire property. This power or this right was a fundamental right that was removed by the 44th Amendment. Also, in Article 31, we had a provision saying that no person shall be denied right to property except by procedure established by law. That provision also was removed, and a new article, Article 300A, was inserted, wherein the right to property was inserted there. And now the right to property is a legal right under the Constitution, but it is not a fundamental right. That important amendment was done in the 44th Amendment of 1978. Also, the 42nd Amendment had modified the term of Lok Sabha and Rajya Sabha from 5 to 6 years. Again, it came back to 5 years. They reinserted the provisions in the 44th Amendment. Then the procedure to decide the disqualification of the member of parliament was also modified in the 42nd Amendment. 44th Amendment, they brought it down again. Again, it was brought it down to the same provision, that is, if the president has to disqualify the members or the ministers, members of parliament, then he can do so with consultation with the election commission only. That was restored. That provision was restored in 44th Amendment. Then, in emergency provisions, Article 352, there are three grounds for national emergency. We discussed that when we discussed the emergency provisions. There were three grounds for national emergency. One was war, then the second was external aggression, and the third was internal disturbance. So, because this internal disturbance word gives the different meanings to different people, they said that we shall not have a vague meaning. Let us make it specific. So they removed that word internal disturbance and put the word armed rebellion in Article 352. So now the president can declare emergency only when these three grounds are there: war, external aggression, and armed rebellion. So internal disturbance is not there; it is removed by the 44th Amendment. So this was done by the 44th Amendment. Then Article 356 was amended. The proclamation of emergency in a state will remain in force for 6 months from the date of its approval by the House of Parliament. Earlier it was 1 year that they brought it to 6 months. Then 359, that is a emergency. During the emergency, the president had a right to suspend any of the fundamental rights under the constitution. They brought the amendment, 44th amendment said that the president cannot amend article 20 and 21. Besides article 20, he cannot suspend, I'm sorry, it's not amend, the president cannot suspend article 20 and 21 even during the emergency. He can suspend all the fundamental rights subject to this restriction. These were the important amendments carried out under the 44th Amendment in 1978. These were the things which were changed in the Constitution. Coming to the next important amendment, that is the 52nd Amendment Act of 1985. 52nd Amendment Act of 1955, there was one schedule added to the Constitution. Till then, we had 9 schedules to the Constitution. They added the 10th schedule, and the 10th schedule laid down a law called as Anti-Defection Law. Please take down this. Anti-Defection Law means that a person who is elected to the Parliament or to the state legislature, once he is elected, he cannot defect from his party or change his party after the elections. If he does so, he can be disqualified by the speaker, and the provisions relating to the speaker and relating to this defection was laid down in this 10th schedule. This was inserted in the 52nd Amendment of 1985, because people vote for their representatives. After they come as members of parliament or members of state legislatures, they are not allowed to betray the people who have voted for them or for their party by changing their party. That is the purpose of this provision. Okay, this is 52nd Amendment of 1985. Then 61st Amendment of 1989. Please remember, 61st Act of 19 Amendment of 1989 reduced the voting age from 21 to 18 years. Earlier, the age of voting was 21 years. It was brought in to 18 years by amending Article 326. This was done in 1989. Next important amendments are two in 1993, 73rd Amendment and 74th Amendment. Both came in 1993. Under 73rd Amendment, a new part was inserted in the Constitution called as Part 9, Roman 9, which dealt with the provisions of panchayats. Of course, panchayats were there earlier, but they were made a constitutional body by putting this what you call as a Part 9 in the Constitution, wherein Gram Sabha should be constituted in a group of villages, and all rural areas there should be constituted panchayats. Then the powers and all the details relating to these provisions are stated in Part 9. Okay, that was added in the 73rd Amendment. 74th Amendment in the same year, they added Part 9A, Roman 9, capital A, was added, wherein, among other things, they constituted 3 kinds of municipalities. That is, one is Nagar Panchayats for people, for areas which are changed from or transited from rural area to urban area. There we have Nagar Panchayats. Then all smaller urban areas, municipal councils were constituted. Then all larger urban areas, municipal corporation. This provision is stated in Part 9A relating to municipalities. Under the 74th Amendment, this came in. Then the next amendment was in 1995. We had discussed this amendment. 77th Amendment, when we spoke about the Indira Sauni case. So 77th Amendment of 1995, after the Indira Sawhney case, this was Article 16(4)(a) was inserted in the Constitution, which says that nothing in this article shall prevent the state from making any provision for reservation in matters of promotion to the scheduled castes and scheduled tribes for to any class or classes of posts in the services of the state, which services which classes are not adequately represented according to the state. Under the suppose the state has an opinion that these classes are not adequately represented, then they can any class of scheduled castes or scheduled tribes, any classes of posts in which scheduled castes and scheduled tribes are not represented, the state can make provision for reservation for promotion also. In Indira Sawhney case, the decision was that reservation should not be made in the matter of promotions, but they made this amendment by restoring that provision, that is, the promotion to the scheduled castes and scheduled tribes was made constitutional by this provision. Then the next important provision is 86th Amendment Act of 2002. In 2002, they inserted Article 21A. 21A gave the right to education. Of course, right to education is included in right to life. That was stated by the Supreme Court when very several cases came before the court. That one important case which we discussed was Unni Krishnan versus Union of India, that is, which was the state of Andhra Pradesh. In that case, the court had held that right to life includes right to education. But then there was an amendment made in 2002, that was the 86th Amendment, where they inserted a 21A, and they said that right to education is available to all children, and the state shall make provisions for all children until they complete the age of 6 to 14 years. 6 to 14 years. So, same way, Article 45 was substituted for early childhood care and education for all children from 6 to 14 years. Next, in the same amendment, for the right to education, 51A was added in the fundamental duties. 51A new clause K. So it was A, B, C, D, E, F, G, H, I, J. So 10 fundamental duties were there. They added the 11th duty, that is clause K, which says who is a parent or guardian, he should provide opportunity for education to his child or guardian, as the case may be, between the age of 6 and 14 years. So it became a fundamental duty to send your child to school between 6 and 14 years. That they added in this amendment, that is the 86th Amendment Act of 2002. Then, after 91st Amendment of 2003, the Anti-Defection Law was strengthened, and the size of Council of Ministers was reduced to 15% of the strength of the Parliament and state legislature. So they cannot have more ministers than the Parliament members of Parliament or state legislative Parliament. It has to be for 15%. It has to be restricted. So this was added. Of course, there are several other amendments which we are not discussing in detail. These are the important amendments which, as students of Constitution, you are required to remember, and you have to see that these Constitution amendments have been incorporated in our Constitution. And so this is an important provision for us to look into. So we can see that we have completed the study of the Constitution according to our 6 units of the Constitution, which we have discussed. So first unit, we have discussed the basic principles of the Constitution, or the salient features of the Constitution. We have discussed the preamble to the Constitution of India. We have discussed the fundamental rights under Part 3, the whole detailed exercise of those rights, the limitations, and important leading cases. We have, in the second unit, we have discussed the directive principles of state policy and the fundamental duties under the Constitution. In the third unit, we have discussed the union executive, the president, the vice president, the prime minister, and the union legislature, and also the parliament, and that is the union legislature, that is the parliament, and the judiciary, that is the Supreme Court of India. In the fourth unit, we have discussed the state executive, governors, chief ministers, and state legislature and high court. And Fifth, we have discussed the constitutional provisions for scheduled castes and scheduled tribes, women, children, and backward classes, and emergency provisions. And the sixth unit, which we completed today, we discussed electoral process and amendment procedure, and 42nd, 44th, 74th, 76th, 86th, 91st constitutional amendments, which are very important for us. So, in the next class, we will go to the scope and aims of engineering ethics, and we will discuss the provisions relating to ethics in next two units, which will be discussing the different principles of ethics, which will be there for the seventh and eighth units of your examination. Any doubt relating to this constitutional provisions which we declare, which we discussed today? Please come on with your doubts or any questions. Anybody? Yes. Are there any doubts? You can all please type your names and USNs in the box so that it will be taken for your attendance in the class. So all of the students, please don't forget to type your numbers properly, USN numbers, and your names. Yes. Any question? Shall we end now? Bharat Kumar, Pranav B, any question? Yes, Sayed Junaid. If there is any question, please. Okay. So there is no question from anybody. I presume that you have understood. Shashank says that there is no question. Anybody who has any specific question, you can. If you have any question even after this also, you can post it on the classroom. Okay, so that it will be clarified. All of you join the classroom, and we are going to have the notes which will be posted in the classroom. All other material will be posted. Please look into all the details which will be posted in the classroom. Okay, so thank you very much for attending the class. Thank you very much for being active in the class. Please see that you keep on studying, preparing notes. Yes, yes, Shashidhar. Yes, you can please see that any doubt is there. Even after this, if you have any doubt, you can raise it by asking questions in the classroom. You can post it in the classroom. All of you have to be members in the classroom. You have to be part of the classroom so that you will be counted for the attendance in the class. Yes. So thank you very much. We will meet on Saturday probably. If tomorrow, then Soumya, I will inform you if tomorrow it is possible, or we will meet on Saturday at the same time. Okay? Okay. Thank you so much.